Yes, oh yes, oh yes. This Honorable Court of Criminal Appeals of the State of Tennessee is now in session. God save the United States, the State of Tennessee, and this Honorable Court. You may be seated.
Good morning. Welcome to the March docket. Let me start by introducing the panel to you. To my left, your right, is Judge Jill Ayers from Nashville, formerly Clarksville. And to my right is Judge Rob Montgomery, down all the way from Kingsport, Tennessee, a nice drive. And I'm Robert Holloway. I'm from Columbia, mule capital of the world, Tennessee. So, welcome. As most of you probably know, each side will have 20 minutes to argue. If the appellant would like time for rebuttal, if you would let us know before your argument. Do we have the timer here?
Yes,
okay.
Your Honor.
We have a timer, and so if you'll watch it, does it go yellow then red? Okay, so watch the timer. It'll start telling you as you're running out of time. Are there any preliminary matters?
Yes, Your Honor. General Coleman has an introduction to make.
Coleman?
Good morning, Your Honors, and thank you for the indulgence. I just wanted to take a moment to introduce Assistant Attorney General Kirby May. Kirby has recently joined our office and will be arguing later this morning. He graduated from Ole Miss. We won't hold that against him. And then he
Not
practiced
until football season anyways.
Yes, Your Honor. And then he practiced for years at the Shelby County District Attorney General's office before joining our office. And I just wanted to introduce him to this court.
Welcome, Mr. May. Good to have you here this morning.
Thank you. Thank you, Your Honor.
Thank you. Anything else you can think of? Rob, did I leave anything out? Nope. All right, would you call the first case, please?
State of Tennessee versus Lamiracle Scott.
Good morning, Your Honors, opposing counsel, and may it please the court. My name is Josie Holland, and I represent Lamiracle Scott by appointment. I'd like to reserve 4 minutes for rebuttal, please, though I don't think we'll need too much time. A little bit of procedural history in this case. I was appointed to this case after the original appellate counsel simply would not file a brief. Particularly with regard to trying to supplement the record with evidence of the continuance that was requested, and that really makes up the bulk of my argument today. I want to make Your Honors aware that I asked appellate counsel for an affidavit about the continuance. That was not provided. So there is nothing in the record to suggest that a continuance was asked for. As a matter of fact, it may have even occurred off the record. However, it was acknowledged in the motion for new trial that such a continuance was requested, and that the judge denied it for two reasons. First, that counsel had made the request too close to the date for trial, and then second, that there is no such thing as diminished capacity defense in Tennessee. And so while we may be headed for procedural default in this, and I would ask that Your Honors not consider this particular issue waived, because the motion for new trial did bring up the subject matter and the judge made a substantive ruling at that time, that I would ask that the court not consider the issue waived. But if this court does consider the issue waived, I would ask that this court note that under Hall and Farrell, a defendant is allowed to introduce testimony from an expert that negates any element of an offense. And while that's not necessarily diminished capacity, a lack of capacity is a defense to any criminal act. Now, as to the rest of the matter, of course, it was caught on video, pretty high quality video. It was admitted that the defendant was the person in the video. And if there are no questions from the panel, I will cede my time to the AG's office.
Let me ask just one question.
Yes, Your Honor.
I don't have it in my notes. When the counsel made the motion for continuance, had there been any motion for the expert to be appointed for diminished capacity at that time, or were they made contemporaneously?
So that was made contemporaneously with the request. There was no There was no expert proposed. There was no written motion delineating what that expert might have presented or what sort of history the defendant might have had, all of which, if Your Honor should decide that procedural default is the correct mechanism here, we would ask that that be included in your ruling as to why. So
Well, I was going to ask about the sleeping juror issue. I think it's the same situation, isn't it?
it is. There's
anything
no
in the
objection made at
So
all.
there's nothing, at least in your first issue, there's reference to a motion to continue in the, I guess, in the motion for new trial and in the trial court's ruling on the motion for new trial. But regarding the issue about the sleeping juror, it's my understanding the record is 100% silent on that. We have nothing in the record.
Your Honors have nothing. And the juror was asleep during closing arguments, not during substantive proof, if the motion
we don't
for new
know.
trial is to be, but we have,
But we don't even know
We don't
when or
even
if the
know.
juror was asleep based on the record.
that's true, Your Honor. All right. Thank you, judges.
Thank you, counsel. Mr. Coleman?
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the defendant's conviction for first-degree murder. To provide a little bit of factual background as to what happened here, on August 22nd, 2020, the defendant shot and killed Mr. Taranza Owens. The two had been romantically involved, and earlier that evening, the defendant learned that Mr. Owens was in a relationship with a different woman. She and the other woman planned to meet up and sort of confront Mr. Owens at his house. He was getting a ride to his house from his cousin, saw them and began to flee in the car, and the defendant engaged in a car chase for a significant amount of time. At some point, the defendant, or Mr. Owens, felt that he had lost her, that she'd lost track of him, and so he pulled over into a gas station. But the defendant found out where he was, came and pulled into that gas station, got out of her car, began to physically assault Mr. Owens, who was unarmed and who never fought back. Excuse me. And then at some point during the attack, she pulled out a weapon and shot and killed Mr. Owens. So that's for that action, she was charged with first-degree premeditated murder.
That is all on video, correct?
That is the video. The video is relatively clear. It shows that Mr. Owens was unarmed. I believe he was, excuse me, I believe he was trying to run away while she continued to shoot him. So everything is on video for the jury to see. The defendant seems to rely on her brief for the sufficiency challenge. So unless this court has questions about the sufficiency, we will also rely on our brief. The main argument that was presented today is this denial of a continuance. And first and foremost, the state would submit that this argument and this claim is waived because there's simply nothing in the record to show that a continuance was ever made. There's no written motion. It's talked about a little bit at the motion for new trial hearing.
Yeah, how do you propose we handle that? Because obviously the trial court acknowledges in his ruling on the motion for new trial that it did occur, that he did deny the motion and sets out his reasons. So how do we handle that in this case?
I think there are a couple of ways. The trial court, my recollection of the motion for new trial is that the trial court did not explain why it denied the motion for continuance. Instead, I think there's a direct quote that I will rely on my findings there. On page 14 of volume 5, the court, I'll have to stand by what I ruled with regards to the denial of the motion for continuance, and we don't have that. So this court could find waiver a number of ways, but I think maybe the easiest is an inadequate record. If we don't have a transcript of what happened there, this court can't review the trial court's determination and must presume it was correct. But if this court engages in a plain error review or even under plenary review, the defendant's not entitled to relief with regards to this continuance because whether this court wants to call it considerations not necessary to do substantial justice under the plain error prong or prejudice under a sort of plenary review, we don't have any proof in the record of the defendant's alleged diminished capacity or any mental health expert testimony regarding that. So even if under plenary review, this court reviews denial of continuance for an abuse of discretion and determines whether the defendant suffered any prejudice. And to do that, for the defendant to meet her burden, she would have to show that had she gotten this continuance, she would have gotten this expert, and this expert would have provided testimony that could establish some sort of defense to her actions, and she hasn't done that. And under plenary review, under plain error review, the burden gets even more insurmountable. Again, we don't know what happened in the records. The record does not clearly show what happened. The defendant can't establish a breach of a clear and unequivocal rule of law, and so consideration is not necessary to do substantial justice. So for all those reasons, this court should find that the defendant is not entitled to relief regarding this continuance matter. I will briefly touch on the sleeping juror question because you had a question, Judge Ayers, and I think the defendant admits there's simply nothing in the record as to whether a juror was actually sleeping, what juror it was, when they were supposed to be sleeping. This matter is simply waived, and without any of that information, I don't think this court could even conduct a plain error review. There's simply nothing in the record to review at all. Unless this court has any further questions, again, the state requests that this court affirm the judgments.
All right.
Thank you.
Mr. Coleman. Ms. Holland, any rebuttal?
Just briefly, Your Honor. There was some testimony that Mr. Taranza Owens may have had a gun that was shot from the vehicle during the chase part of this situation, though on the video it's not clear that he was armed. The court does actually make a link, but as to the question of mental capacity or the question of diminished capacity, the court actually makes kind of a lengthy finding about why it denied the request for counsel to seek an expert. He says, now, as far as the expert witness, depression is not one of those things you know in insanity, and of course you aren't claiming insanity, you're claiming diminished capacity. And then he goes on for a few paragraphs, and he says that, but anyway, diminished capacity, supposedly it doesn't exist in Tennessee, although on every one of these forms now, they're asking that with writing that it in to have them look for diminished capacity. Like I say, a severe mental disease or defect, because of that defect, they didn't know what they were doing. As we're in insanity, they didn't realize what they were doing was wrong. And so even if this court should decide on procedural default, because the trial judge here says he simply didn't understand this court's ruling previously, it might be good for this court to reiterate that expert testimony that negates a particular element of a crime is permitted in Tennessee. And while that might not be called diminished capacity, it is lack of capacity. And as this court decided in State versus Hall and State versus Farrell, such testimony would be permitted. If there are no further questions from this panel, I'll sit down.
All right. Thank you, counsel. All right. Ready to call your next case, please?
State of Tennessee versus Kedron Coppage.